Thanks very much, Don, and good to be here. I suppose the summary of my talk, for those who want to take it very briefly, is that the ACCC probably doesn't have much in the way of a direct involvement in the live export market in particular, but if you look at the range of areas that it does have a role in, so competition generally, but then ports, telecoms, transport, energy, etc. They're all factors that basically add to the competitiveness of the agriculture sector more generally, and of course part and parcel of that is the live export sector. So there's quite a lot of areas of indirect influence that the ACCC has in those sort of areas. So I'll talk about those generally. They're not really that specific to the live export market, but it's worth understanding them. And there are two issues in particular I'll highlight on the way through, because I think they are relevant to the here and now in terms of the live export sector. So if we just start the ACCC, it's a national regulator. It doesn't make the rules, it enforces the rules. It has specific industry responsibilities, water. It has codes like the horticulture and the wheat code, and has a price monitoring role, particularly around things like fuel, energy, mobile telephones and stevedoring. It is an independent statutory authority within the Treasury. 7 commissioners make decisions, and as I said, it's an enforcement agency. It doesn't make the rules. It enforces the rules for the government. The legal framework is the Australian Competition and Consumer Act, and that has quite a number of elements in it. The agriculture unit that I'm associated with was set up by the government as part of its white paper in 2015. And I think quite appropriately it was recognising that whilst a lot of agriculture doesn't understand it, the Australian Competition Act and the ACCC have an underpinning role in a whole range of different areas relating to competition. So whilst I suppose 20 years ago the focus of the agriculture sector was on statutory marketing arrangements, not so much in the meat industry but certainly in the wool industry, in the grains industry, in the dairy industry, they all had their own independent marketing arrangements in place. And we saw the decade of deregulation, I suppose we'd call it that, over the 90s, where most of those arrangements were disbanded. And in effect that meant that most of those markets came within the ambit of the ACCC. And I think my experience is that not many people in agriculture understand perhaps the extent to which the ACCC has become significant in agricultural markets. I think a lot of people think the ACCC is focused on big business, and to some extent it is, but it's becoming more and more relevant to the agriculture sector. Just how it operates, and some people are surprised, it has an info centre which allows people to connect with it. And one of the things I find intriguing is that, you know, there's 100 and, well, where are we? I've gone too far. Roughly 160,000 contacts with consumers come into the organisation each year. It's about 750 staff there. And of those, about 1,000 would get detailed investigation. Half those would perhaps progress a bit further. About 100 end up in some sort of action. So either being taken to court or issued with an infringement notice, or an enforceable undertaking under the law where there's a legal agreement to take certain action. And the thing that intrigues me, and this is relevant to a lot of organisations, the substantial complaints typically come from competitors who see what one of their opposition is doing and decide to dob them in. So despite the good old Aussie culture of not being a dobber, most often those complaints come from a competitor, so that's one to be aware of. Or the second one is, and you'd probably guess this anyway, a disgruntled employee. So an employee who feels they've been badly treated within an organisation will often be the whistleblower that raises a particular issue that ends up with a company or an organisation getting into trouble and being prosecuted for a breach. So those of you that are in business, beware of what your competitors are up to, and beware what your disgruntled employers are up to, because that's typically how matters of substance end up in front of the ACCC. So if we go through some of the laws that the ACCC looks after, the first group of those are what are called the competition laws, cartel conduct. In other words, where organisations decide to work together to get a particular outcome, fixing prices, etc. Misuse of market power, where a large operator in a particular market can influence what happens. Anti-competitiveness agreements, so where contractors or whatever agree to operate together to reduce prices. And mergers, so where a merger is proposed that would substantially reduce competition, the ACCC has the power to take enforcement action to prevent that occurring, or to make arrangements occur that reduce the impact on competition. So if you look at some of those, the cartel conducts, there's been actually quite a number of high-profile cases. The Pratt Visi price fixing around cardboard packaging was quite a prominent one. There was $30 or $40 million worth of fines handed out there. And even just in recent times, there's been Colgate Palmolive and Cement Australia, both subject to fairly substantial fines because of evidence and proved in court that they were engaged in arrangements to reduce the impact of competition on their business. So that's a fairly high profile part of what the ACCC does. Those cases don't come up all that often, but they are usually pretty substantial, and there's some underfoot at the moment in relation to shipping, so there's and air freight. So those two are areas where there's currently investigations and court actions underway, and no doubt you'll hear a bit more about those not too far down the track. The other area, of course, is mergers. Probably the most prominent mergers we're seeing at the moment, there's a set of three actually, Dow DuPont, Syngenta ChemChina and Bayer Monsanto. So we're seeing 6 of some of the biggest agrochemical companies being merged to 3. Now those will happen at a global scale, but in fact they will require consideration at a domestic scale as well. So the ACCC's role in that is to look at the extent to which those products from those companies overlap or compete with each other, and what the impact of that will be in terms of competition further down the track. So quite a deal of effort goes into those sort of investigations. Fair trading, that really relates more to consumer type issues than it does to perhaps business, but it deals with things like misleading and deceptive conduct, unconscionable conduct, and consumer guarantees. One of the more common issues that the Commission actually deals with is the consumer guarantee level, where, for example, a lot of online platforms might say no returns, well, which in fact is illegal under the Australian law. You have to offer the ability to return product and replace it if it's found to be defective or you change your mind. So those sort of issues are dealt with fairly commonly. The misleading or deceptive conduct is one that is useful to understand. There's 2 cases there. One was Aussie beer, had an Australian map on the label and was labelled Aussie beer. It was actually made in China. It didn't claim it was made in China, but this is the useful point to understand about misleading and deceptive conduct. It's judged on the basis of the overall impression created, not the strict wording of what you look at. So in that case, there was prosecution, successful prosecution for misleading and deceptive conduct, and similarly in this case, where this was actually not honey, it was actually plant sugars, and it was made in Turkey, not Victoria. So in that instance, but the point, and the reason I'll just emphasise this, we're certainly seeing an increase in what we might call provenance labelling of things like beef, for example. So grass-fed beef, pasture-fed beef, natural beef. there is an issue there that if we're not careful about those, the situation can come where someone takes that to the ACCC and says, I think I've been misled, in which case this will be the sort of test that's applied. Is it reasonable from a consumer's perspective that the labelling reflects what the reality is? And you know, I think that's certainly an area of caution. Free-range eggs is a classic example where the industry couldn't agree on standards. There was a lot more free-range eggs on the market than it was obvious could be the case from the number of hens actually running around free-range. And there's been 4 prominent prosecutions, some of them ending up in hundreds of thousands of dollars of fines, because even in the case of one, the most recent one in Western Australia, whilst it was true that the hens did have access to free range, there was an opening of about a square metre for 52,000 hens in a shed. And of course the reality was 99% of them didn't get outside on any particular day. So even though technically speaking that was a free range situation, the finding of the court was, well, you've misleading and deceptive conduct there. So when it comes to those issues around labelling, particularly provenance issues in the beef industry, I think, and we've already seen it a little bit with the pasture-fed beef thing, I think that is something that we certainly need to keep in mind. The unconscionable conduct is a higher order of that in many respects, but typically where a very big company imposes conditions or requirements on a supplier or a partner in trade that go above and beyond what you'd normally expect. So we've seen the classic case of, for example, Coles running short of profit one year and going back to suppliers and saying you all have to tip the bucket for extra money. That prosecution was successful in the court. There was about a $10 million fine imposed on Coles in that case, and another $12 million in restitution to those suppliers administered by Jeff Kennett. So that is certainly an area, it's probably not directly relevant to the livestock industry, but it's certainly an area where big companies need to be careful in relation to those sorts of things, and there's a prosecution underway at the moment on the same terms for Woolworths. So that's certainly something of interest. As I said, the consumer rights, the repair and replace and refund, all those sorts of things are in fact governed by the law and judged under the ACCC's ambit, so that's something that is worth looking at. Infrastructure, regulation and monitoring, that's a fairly significant area of the ACCC's activities. And you may have noticed, for example, the ACCC released a report on fuel prices in Darwin not long ago, where it was found that the Darwin fuel prices were 25 to 30 cents above what could reasonably be expected. And in fact, it was interesting, the minute the report was released, the fuel prices came down in Darwin. So that's more a monitoring role. Despite a lot of claims that are made by politicians and others, the ACCC doesn't have a regulatory role there, it simply has a monitoring role. And in fact, it can be quite a useful thing to have the highlight occur of disparities in things like fuel prices, and that certainly seems to create a response. Monitoring ports, there's a lot of debate about the moment in relation to things like the Port of Darwin sale, the Port of Newcastle sale, the Port of Melbourne sale. What tends to be the case is states and territory governments tend to want to sell them off for maximum value, and of course maximum value means minimum regulation. So the less regulation they put on those sales, the more value potential buyers are likely to pay. So we've certainly seen in all those 3 cases quite considerable concern raised about the likely impact of that sale on future port prices. In fact, a substantial court case launched in the case of the Port of Newcastle, which is underway at the moment, because of course the buyers there bought that port with minimum regulation and overnight doubled the port charges, and that now has been the subject of a court case. It is interesting because there is a provision in the Australian Competition and Consumer Act to actually declare certain infrastructure to be strategically important and therefore to come under regulated pricing. and the question that's sitting there at the moment is the extent to which that should happen, particularly in relation to ports. In the case of the Port of Newcastle, the courts have actually said it should be a designated infrastructure and therefore come under regulated pricing. That's still presenting itself at the High Court, and no doubt it'll be sorted out. But certainly ports like Darwin, Townsville, etc., there's certainly some interesting questions being asked about whether privatisation is the best option in those situations. Telecommunications is the other one, and you may have noticed the ACCC has launched an inquiry into whether or not there should be mobile phone roaming in Australia. Now roaming is basically talking about the situation where competitive telecom providers should or shouldn't be given access to towers put up by their competitors. So in the situation, for example, where Telstra might have the only tower in a district, should competitive telcos also, for a fee, be given access to that so that they can offer competitive services? It's a very vexed issue because, of course, the telcos that have got the towers there say, well, we wouldn't have invested if we knew that our competitors were going to be given access to it. But on the other hand, when you look at it economically, there's really no justification for a competitor tower to be created. The single tower will cover more than the demand in that particular region, and therefore the potential exists that there will never be competition in the supply of telecommunication services. And of course, we already see that in one of the major telco providers already having a premium of about $15 a month in terms of the cost of their plans, and generally it's understood that's largely on the basis of their superior coverage. So that is afoot at the moment. It's creating quite a lot of debate. It's very relevant to regional areas and regional and remote areas, and so it's worth having a look at. But the role of the ACCC in that will be actually to make a declaration, and if it declares that roaming should be mandatory, then competitors will be able to get access to those towers. They'll still have to pay for them, but at least the potential might be created for a competitive mobile phone provider. And similar situations apply in relation to electricity and gas. I'll cover off on that. We've seen the petrol pricing stuff. Market studies is a new area that the ACCC started to undertake, and this is not uncommon amongst competition regulators globally. So rather than just being focused on individual investigations, the organisation says we'll take a more detailed look at particular markets and get an understanding of those, and perhaps even be proactive in heading off problems. There's been two completed studies done. One is the Eastern Australian gas market, the other is the motor vehicle servicing market study, and that's looking at this situation where when you buy a car you can only get it serviced at the licensed dealer, etc., etc. The third one, launched specifically within the agriculture unit, has been the beef and cattle market study. That study's been underway for the last 6 or 8 months, and the draft findings of that will be released next week on Monday. So it's really a study that's looked at a number of issues that emerged in the beef industry over the last couple of years. Some mergers, particularly the Primo JBS merger, and some issues like what's called the Barnawatha incident, where for some reason all 9 buyers at the Wodonga sale yards didn't turn up on one day, all with different excuses for not turning up. Pure coincidence. So those triggered a request to have a more detailed look at the beef industry. That process has been underway since April. As I said, the draft report will be out on next Monday, and it makes some recommendations about some potential changes in the beef industry in terms of how the markets operates. And I guess to some extent there may be some interest from the live export industry in relation to some of those, particularly around price transparency. The other area that I want to talk about, and this is one that may be more directly relevant, is what's called the unfair contract terms. So that's a new law that's been introduced, and I guess in summary it basically says that if you've got standard form contracts, in other words, take it or leave it contracts. The classic example is a mobile phone contract where the requirements on the two parties to that contract are dramatically unbalanced. So again, using that mobile phone example, if, for example, the phone contract said it's for 3 years and if you want to get out of this you have to pay out the full 3 years, but on the other hand the telco reserves the right to change the service or the pricing at any stage during that 3 years, you'd look at that and say, well, the requirements on the two parties to that contract are significantly unbalanced, and under the law the court can then strike out that contract clause that's considered to be unbalanced. So where that becomes relevant in the livestock industry is, of course, standard form contracts for example, the sale of cattle, where the contract might have arrangements in there about who bears responsibility for transport, insurance, mortality in transport, those sorts of things, where if you look at it, it appears as if the contract is basically unbalanced, that the risks borne by the producer or the processor or the buyer in that case are way out of whack, and therefore a court would likely strike that out. The ACCC has been doing some work talking to a whole range of different providers of those contracts, including in the livestock industry, and it's actually been quite interesting that where it's been pointed out in advance of this law that it's likely that a particular clause in that contract would be considered unfair, the companies have been quite cooperative in striking those out in advance of that law coming into place. So you'll hear a little bit more about that in the next few weeks, but it's certainly relevant to the agriculture sector in things like for example, cattle sales, grain sales, those sorts of things. So it'll be certainly something to keep an eye on. So I think I've covered off most of the areas that are relevant to the industry in terms of the role of the ACCC. I've highlighted two areas I think are worth keeping an eye on. One is that misleading and deceptive, where it comes to describing a product, probably not so much in the live export sector, but certainly in the beef sector more generally, where it comes to labels like natural or pasture-fed or those sorts of things. And the second is this unfair contracts. I think businesses involved in the industry might want to have a look at their contracts and just make sure that the clauses in them wouldn't end up getting them in jeopardy in terms of a court looking at that contract and saying, well, that's unbalanced, we strike out that clause. Just to be clear, it doesn't mean that the whole contract is nullified, but it does mean that those clauses would be judged not to apply. So that's worth keeping an eye on. So in summary, the ACCC, as I said at the start, doesn't really have a direct role in regulating the livestock industry or in a lot of the areas that might be considered a potential to increase their competitiveness. But a lot of the issues the ACCC deals with have an indirect effect, and that's, of course, all those infrastructure issues, the energy, the ports, the fuel, etc. And certainly I've found that having a bit more of an agricultural perspective there is certainly something that generates a good response on issues like internet access and mobile phone access and fuel pricing. I think it's fair to say that there's not a good understanding of the situation in the bush, and when you point out that you may not have any choice of mobile service provider because, of course, the coverage you can get from any alternative is almost zero compared to the main supplier, I think that's a good perspective to bring to the work of the ACCC. So I'm hoping that that's bringing some benefits more generally. And it's certainly highlighted to me that I think the agriculture sector hasn't understood the nature of the role of the ACCC in a lot of its markets, and doesn't necessarily engage very well with the ACCC processes. The large companies tend to have specialist expertise who know the ACCC processes around a merger or around a particular prosecution. But when it comes to inquiries, I think agriculture more generally doesn't really have a good level of engagement with the ACCC, and hopefully some of my work will improve that over time and perhaps help the competitiveness of the agriculture sector more generally. So thank you very much.
Thanks, Mick. Any questions? Please, yes. One down the back. There's a mic there.
Hello, David Jupp, Holstein, Australia. Mike, I'd be very interested to hear your comments on some of the recent behaviour of the milk processors in Australia in terms of pricing and dealing with their
Did you say milk processors?
Milk processors.
Yeah. The behaviour of the milk processors is subject to two separate actions within the ACCC. So both Murray Goulburn and Fonterra are the subject of investigations, and the nature of those investigations is whether the actions of both those companies could be considered to be misleading and deceptive, so that's the first level of a potential breach of the Act, or in some cases unconscionable. In other words, they used their scale to impose conditions on their suppliers that really would be considered, just not normal business practices in the same manner of the Coles matter. So both those investigations are underway at the moment. So the nature of the ACCC work is that it collects the evidence and it acts as the prosecutor in that sort of a case if it's judged that there's a substantive case there that a court would find a breach. So that process is underway. Exactly how long it will take before that comes to a head in terms of a decision whether to go to court proceedings or not is a little bit hard to say, because of course there's evidentiary proceedings underway. I suspect it's not that far away before there'll be more noise about what's happening there. The second thing that is on the 29th of July, there was an announcement by the Agriculture Minister of a broader inquiry into contractual arrangements in the dairy industry in Australia. That is a special inquiry initiated by the Treasurer, and it's important in that it incorporates mandatory information disclosure powers to the ACCC in relation to that issue. So once that inquiry gets underway, the ACCC will be able to issue demands on participants in the dairy industry to bring forth information about, for example, the relative pricing and profitability of different product lines and all that sort of stuff. So it will potentially be a very detailed investigation more generally across the dairy industry. And a lot of the focus of that, as I already mentioned, will be on the contracting arrangements and risk sharing. The fact that, if a dairy processor stuffs up, under current arrangements, it can go back and claim the money from its suppliers, which certainly wouldn't pass the test in terms of the beef industry. So both those are underway. We'll hear more about the first, I suspect, in the next few weeks. The other is a more substantial inquiry that will probably take 6 to 9 months and encompass the whole industry.
Further questions?
They're all scared.
They're all scared. They're all scared. Yeah. Thanks. Oh, hang on, Mick. One over there. Terry Enright. Terry. There's Mike coming, Terry.
Thanks, Mick. Where do you draw the line between where you, in the examples you gave, where you can actually take action, and other ones where you just monitor it? Things like fuel company. I mean, why can't you have a look at fuel, for instance, and see whether there's or stevedoring or airports or something of those things? Who draws the line?
It's the nature of the legislation and what the legislation says. So in some areas it confers powers on the ACCC to act in a regulatory fashion. In other areas it simply provides a reference to monitor prices in those. So it really is the fact that the ACCC is an enforcement body, not a policy setting body. So if the government wants to hand those powers over, that could happen, but at this stage that's the arrangement.
Where are we going? Any more further questions? No? Mick, I just got one quick one, just purely out of interest. maybe your time on the Commission has not been long enough yet, but is there ever a history of re-offence? If somebody reaches the 100, the group of 100, do you ever see re-offenders?
Look, I'd be chancing my arm to have a guess at that. Typically, from what I've observed, what you tend to see is once an organisation understands that it's in breach of the Act, and some of those breaches, for example, the collusion type breaches, potentially risk penalties up to 10% or 15% of annual turnover. So they're actually criminal prosecutions. So some of them tend to be quite serious in their consequences if they are found to be a breach of the Act. So typically companies tend to set up very close collaborative processes with the ACCC to make sure they're following. So some of the major supermarkets, for example, have moved to quite collaborative arrangements to make sure proposals they're bringing forward actually meet the test. So it probably is a fact that even though there's only a small number of prosecutions or actions each year, they do have a fairly substantial curative effect, if you like, on participants in the industry.
Yeah. Okay. Thanks, Mick. Thanks very much.